Okay, I'm Bob Friedman. We had quite a few technical difficulties because this is my first time doing a Zoom webinar. Thank you for your patience. I normally give 10 presentations, live presentations a year, and I was only able to do one this year. So we'll proceed here. I'm Robert Friedman of Friedman Ranzenhofer Attorneys. And once again, thank you for joining me today. And I must be the only participant left. Well, there's a couple of participants left. I have a few warnings before we start. This is not a substitute for legal advice. Laws are constantly changing, and we have a tremendous amount of material to cover in a very short period of time, especially short now that we've gotten a late start in presenting this program. So, and my thanks to the Amherst Center for Senior Services for sponsoring this webinar today. When someone enters a nursing home, long-term care expenses need to be paid a number of ways. First is from fixed income. Next, it may be from your investment income. You may have to sell your home. Long-term care insurance, Medicare, which covers in full for the first 20 days, and then next 80 days as copay, possibly from your VA pension. And the last resort is for Medicaid. And we have a tremendous amount of material to cover today. And all this material is available on my website, or if you have any additional questions, you can present these at the end. All this material will be available on the website. Medicaid is a last resort for paying for long-term care costs. And Medicaid eligibility, it's a bizarre system. And first of all, it's based on financial need. So first off, for income eligibility is maximum of $875 of monthly income for institutional care, or excuse me, $875 for home care, or $50 for institutional care. Resources, you're permitted to have only $15,750 in resources, as Medicaid is based on financial need. Many of you have heard about the look-back period of 5 years, and we'll explain that to you and the various exceptions. Effective with applications January 1st of 2021, there will be a look-back period for those who apply for Medicaid for home care. Prior to that, there was no look-back penalty for making gifts during the 5-year look-back period. So for any transfers that are made as of October 1st, you will be penalized for making those transfers or gifts. And that will be for all applications that are made on or after January 1st, 2021. Now, the way the penalty period for transfers of assets works is, for instance, if you were to make a gift of $107,200 total over the past 5 years, either by giving property to someone for less, or selling property for less than its value to a family member, or making gifts of cash of $107,000 over the past 5 years, what they call the regional rate for 2020 in Western New York is $10,720. So if you had given away $107,000 over the past 5 years, and you live in the Western New York area, that will be divided by the average monthly cost of nursing home care in Western New York of $10,720. So there'd be a penalty period of 10 months. So you would have to private pay for nursing home care for 10 months. So first off, if you do make gifts, you need to properly document those because assets that are transferred for the purpose of qualifying for Medicaid will result in a penalty. So, for instance, I do advise that you have frequent medical checkups to establish that when you made the gifts, they were not made for the purpose of qualifying for Medicaid. Also, as a general rule, transfers of under $1,000 will not be questioned. So this all comes about is when someone files an application for Medicaid for either home care or for nursing home care, they will have to provide 5 years of banking records, and the social services will inquire as to gifts of usually of $1,000 or more. That's a general rule. They may inquire for gifts of smaller than that. Now, many of you may have heard about that you can give away $15,000 per year. Well, that has nothing to do with Medicaid. That is under the U.S. state and gift tax system, in which, in addition to your annual exclusions, you can give away $15,000 to as many people as you want every year. And if you're married, $30,000, and not have to file a U.S. gift tax return. It has nothing to do with Medicaid. You will still be penalized if you do make gifts, even though they may not be subject to U.S. gift tax. New York no longer has a gift tax. So they also look at past patterns. If you normally make gifts for birthdays or weddings, you may not be penalized for that. So what this all means is that basically is that some gifts that you've made in the past 5 years, you may not be penalized for if they were not done for the purpose of qualifying for Medicaid. In other words, if you were in perfect health and you're making these gifts, you may or may not be penalized. Now, one overriding thing that you need to think about is that you may not want to deplete yourself of your assets in order to qualify for Medicaid. Because even though nursing homes are not allowed to discriminate against Medicaid patients, if you've made gifts in the past 5 years, or if your assets are substantially less than $100,000, nursing homes will not even accept you for rehab because they prefer to have private paying patients in case they do get stuck with a patient after rehab. So you have to keep that in mind. If you want to have your choice of a good nursing home, and even some of the better nursing homes are not that great, that you may not want to make gifts or plan around qualifying for Medicaid. It's one overriding question that you need to discuss with your advisors. There are protections if a nursing home patient has a husband or wife who's still at home, so that husband or wife can have enough to live on. So if there's a spouse at home, that spouse can keep up to $128,640 in assets, and this is in addition to the home, which we'll be talking about. Also, the spouse at home can keep combined income of $3,216, and depending on the circumstances, up to 75% of combined income over the $3,216. Also, no matter how much a spouse in the community has in assets, that spouse, so even if you're in a nursing home and your spouse has $3 million, your spouse can sign a spousal refusal that they will not support you and you will qualify for Medicaid. However, there is a possibility that the county attorney could go against the spouse to collect for Medicaid paid, but that would only be at the Medicaid rate, which is considerably less than the private pay rate. Third, you should consider updating your will. If your spouse is in a nursing home, you may want to disinherit your spouse so that if you pass away before your spouse, that not all the money will go to your spouse and therefore to the nursing home. So what you have to keep in mind, that's why you have to talk to your advisors, your legal and tax advisors. There's many assets that do not pass through probate. And I'm presenting a webinar on that on October 7th at 10:30 a.m. And the advantage to these assets, we'll discuss what the pros and cons are to having your assets go through probate. But one of the advantages is that non-probate assets cannot be levied against when someone passes away. So when a nursing home patient passes away, there can only be Medicaid recovery against their probate assets, not their non-probate assets. And we're seeing more and more that people's assets that are non-probate are growing probably in excess of what their probate assets are. Life insurance, if you have beneficiaries in your life insurance policy that is a non-probate asset, IRAs with beneficiaries are non-probate, does not pass through your estate. Annuities would have beneficiaries. There's various types of bank accounts. There's joint bank accounts, payable on death bank accounts in trust that may or may not pass through a probate. Also, one automobile up to $25,000 can be transferred without probate. Living trust, we'll talk about that. Those are not passed through probate. And you can have your stock accounts set up as transfer on death. Your investment accounts can be transfer on death. So they do not have to pass through your estate, but are paid directly to your beneficiaries that are named there. Now, if there's one thing that you learn from this presentation is that having a power of attorney with a gift rider is an absolute necessity, especially for those who have never pre-planned for the possibility of preserving their assets for nursing home. So with powers of attorney, they're either immediate or springing. Most people, 99% of our clients, get immediate powers of attorney that go into effect immediately when they're signed and when their agents sign it. Or some people want a springing power of attorney, which does not go into effect until a certain event occurs. Usually a doctor signs a certification that the person is incapacitated, and then the power of attorney goes into effect. One thing that powers of attorney can avoid are guardianships for someone, what's known as a mental hygiene Article 81 guardianship. And I'm doing a webinar next Wednesday on that. Get information on that on our website through the sponsored by the Center for Elder Law and Justice on the guardianships. So typically people will call me and say that their loved one has a stroke or some other unforeseen disability, and they need a power of attorney or healthcare agent or healthcare proxy signed. Well, if the person may not have the mental capacity or the physical capacity to sign these documents, in that event, then guardianship has to be done through the Supreme Court. There were numerous changes to the power of attorney enacted in New York as of September 1st, 2009. If you have powers of attorney that were executed before that, they're still valid, but there were widespread changes in powers of attorney. And one of those was they have a separate gift rider. If you want to authorize your agents to make gifts in excess of $500 per year, then you need to sign a gift rider, and that's signed at the same time as the power of attorney and witness. And that gift rider can authorize gifts to the agents or other people. And this gift rider is essential for what we're going to be talking about a little bit later about emergency and Medicaid planning. You need to have either that gift rider or a guardian appointed with that authority to do that. Also, the new law that went into effect 2009 states that agents have fiduciary duties to the principals who sign the powers of attorney, which means they have the same duties as a trustee or executor to act in the best interests of the person that has given them power of attorney. All the powers of attorney are durable, which means if you later become incapacitated, it's still valid. Also, the agents must, if a guardian is appointed, sometimes the guardian still has to be appointed, even with a power of attorney, especially if an agent is not acting in the best interests of the principal. then the agent is required to provide a full accounting to the guardian. Also, the new forms require that the agent also sign the power of attorney to make it valid. The primary agent must sign. The successor agents don't have to sign at that time, but the primary agent does. Also, there's a HIPAA provision in the document that authorizes the agent to obtain your health protected documents. Also, it provides, the power of attorney also provides that that third parties must accept, such as banks, must accept the power of attorney. Long-term care insurance, it's just another way of paying for long-term care, also for in-home care. And I generally do recommend it under the right circumstances. You should do it while you're healthy, because if you have some health conditions, you may not be able to obtain it. The laws are constantly changing. And as we're seeing, government may not have enough availability of Medicaid in the future, and they're going to make the requirements stricter and stricter. Also, a good thing about long-term care insurance, it covers home care and also assisted living. There's basically three types of long-term care policies, and you should speak with someone, an insurance agent that's familiar with these. There's traditional long-term care insurance. There's hybrid long-term care insurance, which also provides life insurance combined with life insurance. And there's a New York partnership plan policies. There's very few companies that are still offering long-term care insurance. The New York partnership plans, they provide you with coverage, and then when the coverage ends, you automatically qualify for Medicaid regardless of how much you have in resources. However, your income would still have to go to the nursing home. It doesn't protect your income. One option to preserve your assets is to transfer your current home to your children with a life estate deed. This is accomplished by you sign a deed and to your children, and you reserve life use of your property, which means that you have the right to occupy the property, and you still pay the taxes, and you still get the property tax exemptions. And this would be a non-probate asset. Upon your death, it would automatically pass to your children, who would not pay capital gains because they would get the stepped up cost basis just as they would if they inherited it from you. The drawbacks to the, a few drawbacks to the life estate deed, which you need to discuss with your legal advisor, is that if your children who you deeded to were to go bankrupt or have judgments against them, that would affect the property. And we have seen cases of this where children go bankrupt and then substantial amounts of money may have to be paid to the bankruptcy trustee. Another drawback is, as opposed to putting your house into a living trust instead of a life estate deed, is that if you decide that you want to sell your house in a few years, then the proceeds from the house are no longer protected. You would have to start all over again as far as any 5-year look back. Another alternative, and it's different than giving or transferring your home to your children with a life estate deed, is that would be with your children, excuse me, if you were to sell your current house and then purchase a life estate interest in say your children's home, or you and your children buy a home together and you have a life estate interest in that, as long as you live there for 1 year, that house would be protected. So that would not be your current house. It would be a house that you purchase with your children, or if you give your children money to be able to have use of part of their home. There are numerous exemptions for your primary residence where you're living. There's an $878,000 equity exemption, which covers most houses in Western New York. For the 6 months, first 6 months, if you're intending on returning home, or within the first 6 months of being in a nursing home, your primary residence is exempt. That would be the applicant would have that. Also, You can transfer your house to your spouse, and that would be exempt. It's not going to be considered as a resource of yours when you qualify for Medicaid, or it can be transferred to minor disabled or blind children. Also, your primary residence could be transferred to a sibling with an equity interest. So if a brother or sister has been living with you for 1 year, at least 1 year, and helping you with the expenses, you could transfer the house to them if you were a nursing home patient. And there again, it'd be very important to have a power of attorney with a gift writer for your agent to be able to sign a deed over to your brother or sister if you were in that situation of being a nursing home patient. There's another exemption which preserves your home, which we see quite often, and that is a caregiver child who's been residing for the past 2 years with you. So usually the child's been there their whole life, but if you have a caregiver child that's been living with you for 2 years immediately before you go into a nursing home, not if you're going directly to not only if you're going directly to a nursing home and not if you're going to an assisted living, but you can transfer the house to them and there's no penalty, there's no look back for doing that. That can be done. The living trusts, living trusts are an example of a non-probate asset. They're also known as inter vivos trusts, either revocable or irrevocable. For Medicaid planning, the trust would have to be irrevocable. You do have to give up certain things if you want to preserve your assets for Medicaid. So people can put their house in an irrevocable trust. They appoint usually their children as trustees. Both trusts, revocable and irrevocable, avoid probate, but only the irrevocable trust would preserve their assets for nursing home care. So here again, the advantage, you could put your house in an irrevocable trust. You could deed your house to it, set up an irrevocable trust and transfer to them, live into your children. The advantage of that would be a number of reasons over a life estate deed is that if your children are sued or go bankrupt, it has absolutely no effect on your house. If you decide after a few years you want to move somewhere warmer, the trustees would sell your house and they could buy you a house in Florida and you don't have to start over again with a 5-year look back. Another asset that is not considered as part of your resources for Medicaid planning are the prepaid funeral account. You would set that up with your funeral home. IRAs, if they are in or 401ks, if they are in a payout status, they're not considered as a resource when you qualify for Medicaid for the $15,450 limit. The distributions will be considered as assets, but the IRAs or 401ks will not disqualify you from Medicaid. Now, if you want to reduce the required minimum distributions to stop them in order to minimize what's going in the nursing home, talk to your investment advisors about a qualified longevity annuity contract, something that was enacted within the past couple of years. Also, when I talk about IRAs, I'm not talking about Roth IRAs. Roth IRAs are considered resources and they're not protected if you are applying for Medicaid. Caregiver agreements. So your child's been, your son or daughter has been caring for you for the past year, and you decide you're going to compensate them $50,000 for that. Is that considered a gift, or is it considered income? Well, it'd be considered a gift. The only way you can pay for caregivers in your family, which avoids family disputes, is that you have to have a caregiver agreement which defines what their duties are, state what the pay is, and you can do reasonable pay in advance if this is all documented. However, the disadvantages of that is that your caregiver has to report that as income. It's not a gift, it is income. with the reported as income. And the Department of Social Services dislikes these agreements, and they will scrutinize these. So if you're going to consider a caregiver agreement, you should have it executed or prepared by an attorney. You can make unlimited amounts to disabled children. There's no look back period for that. You can make unlimited gifts to disabled children of property or cash. Talk to a legal advisor about possibly putting that into a trust for them. Spend down your assets. Your automobile is not considered as a resource in qualifying for nursing home care. You can pay off debts, make home improvements. Now, emergency Medicaid planning and promissory notes. This is where a power of attorney with a gift rider is essential. And we receive calls at least once a week from people who are putting their relatives, putting a mother or father into a nursing home who doesn't have, who has done no planning at all for Medicaid assets. So basically, for those who have never done any planning for Medicaid and have substantial assets, or even just a house or have a house in their name, there is a technique to preserve half their assets and still qualify for Medicaid. That's what's known as emergency Medicaid planning with promissory notes. So basically, if someone does have a power of attorney with a gift rider, or we have also initiated guardianships for the purposes of making gifts, and the judges will order will grant guardians the power to do this emergency Medicaid planning, in which only half of your assets have to be used for nursing home care, and when half of the assets are depleted, then you will qualify for Medicaid. So it does involve 2 Medicaid applications. The patient makes a gift, for instance, of all their assets to the child. The child promises to repay half of that, and it's a very precise calculation. And an application is made initially for Medicaid, and with the purpose of getting turned down for Medicaid, actually. And then when the half of the assets have been depleted, then another Medicaid application is submitted, and the patient will qualify for Medicaid. So this is, you still fill out your nursing home applications the same way, and the gift can be made if you have the proper power of attorney with a gift writer or a guardian that has that power. Healthcare proxies and living wills, another very important document that you need to have. You have a constitutional right to refuse treatment. The only problem is that you may not be able to communicate that. So healthcare proxies and living wills and most medical orders for life-sustaining treatment, which are prepared with your doctor, are all known as advance directives, which you can designate in advance whether or not you want to be kept alive. If you're in a coma, terminal illness, non-terminal illness, whether or not you want tube feeding. Now that has to be specifically stated. The healthcare proxy law came about by New York legislation. You appoint an agent and one alternate agent to make healthcare decisions for you. And a living will, we do a combined document, is your specific directions regarding your healthcare. And you have, if you do not want tube feeding or artificial hydration, you must state that in the living will. Also, you can have a HIPAA authorization in your living will, which many of you have filled this out in your doctor's office, which authorizes your healthcare agent to have access to your healthcare information. Now, for further information, we covered a great deal of material in a very short period of time. Feel free to call me with any questions. You can visit our website, fill out a contact form there. We do have a Medicaid guide, which explains all this on the website. This video will be on our website, and feel free to email me if you have any questions. And I will go over to the screen here and see if we have anyone that's entered any questions. One question that we did receive was that someone, there's a question whether someone needs to do a life estate deed if they have long-term care insurance. If they have a New York Partnership long-term care insurance, they wouldn't necessarily need to do a life estate deed because they would qualify for Medicaid after the long-term care payments had been made, and so the house would be protected. But you may want to check further with your legal advisors to see what's the best form of ownership for that, for a number of reasons. So I don't see there's any questions here. Once again, thank you for your patience and waiting for the start of this presentation. And feel free to ask me, contact me if you have any questions.